Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast. That is, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. I'm Paul Gigot here with Kyle Peterson and Alicia Finley. So this is a pretty speech-friendly court, First Amendment-friendly court. Where do you think it's going to come down on this Murthy versus Missouri case?
My guess is that they'll come up with a test that is broader than the federal government and the Solicitor General's office is arguing for, but perhaps not as broad as the injunctions in the lower courts that were issued that are now being presented to the Supreme Court. Just to follow up, I mean, that argument that the Solicitor General's office was making that if you're in the executive branch, you have no power over 230. So how could you possibly coerce a social media site with regard to 230? I don't buy that. And I don't think the justices are going to buy that either, because if you're a senior official in the White House, you have a huge ability to set the agenda in Washington. And so I think some of this stuff that you're seeing in the record in this case is going to be deemed coercive. And it is worrying. I mean, there's an email from somebody at Meta to Surgeon General's office saying, our teams met today to better understand the scope of what the White House expects from us on misinformation going forward. And I think it will be hard for the Supreme Court not to find things like that and the context of that as coercive, just given the pressure that those platforms were under.
Alicia, I agree with that. I think that the Bantam Books precedent that you cited is going to be compelling in this case, and I think plaintiffs will win. What do you think?
I agree. And just one other point on this, I think you need to consider all these statements in context. And that was actually in the second case that the Supreme Court is hearing on Monday involving New York State officials basically jawboning banks. The important ruling that the district court made in that case was you need to consider all these comments or threats in the broader context. So even if the individual comment alone isn't considered coercive, when you consider the broader context, their basically political campaign is.
So if there's a continuing barrage of comments and threats and regulator statements, that is the context that has to be considered here. All right, there's another case that the Supreme Court made a decision on Friday, 9-0, which was written by Justice Amy Coney Barrett. And the decision was concerned as a couple of cases when the politicians can block social media critics, social media commenters on their sites. The plaintiff said they can't do that. That's a violation of their First Amendment rights. The public official said, oh, no, this is just my personal site. I wasn't speaking for the government. Where did the court come out here?
Right. So on both cases, they didn't clearly decide, but they essentially set forth a standard which rejected the argument that any public official couldn't bar constituents from following or posting on their personal account. Now, what was helpful, at least in my view, is that the Supreme Court laid out actually a new kind of test and a standard for determining when maybe local officials are actually posting in their private capacity or public capacity. Because in a lot of examples, you have government officials, politicians who use private accounts, AOC, Donald Trump actually, who use their private accounts to post about government jobs and government affairs. But the court helpfully ruled that that is not state action, and that doesn't mean they de facto become public forums.
Just so I understand here, Alicia, does this mean so Donald Trump posts in his personal site on True Social and says, I'm going to slap 100% tariff on any cars coming into the country, and I decide to say as a critic, post, that's outrageous, Mr. President. I think it's a terrible policy. He can block me.
Right. At least under the standard that the Supreme Court laid out, because government officials do have free speech rights too, and they can express themselves and express their views on matters. So if Donald Trump was president, right now it technically wouldn't apply to him, or this court ruling wouldn't apply to him. But if he were president and made that statement, yes, he could.
What, he could block me?
He could block the post.
Even though he's president?
Well, it's partly a personal account, but he doesn't have the actual authority to speak on the state's behalf with this account. And he's not purporting to exercise that authority, or at least in my view, when he's speaking on social media, he's expressing his personal views.
All right. So when can public officials not block critics?
Well, one is when they actually have an official account. So if this is an official government account, they cannot. And there are a lot of official government accounts, right?
Right, sure.
But also when they are actually say that they're speaking on the government's behalf and they have the actual authority to do so.
All right, let me keep going here. So if you're a city council member and you have the power to obviously oversee a city budget or a city regulation or something, at least you can cast a vote. And I lambaste you for that vote on social media. And it's your personal Facebook account, but you often use that personal Facebook account to comment on public affairs or on different rules. What's the line there?
Well, I think as the Justice Barrett noted in the opinion that these aren't necessarily fact-intensive inquiries. And you have to consider the fact that there are a variety of different and rapidly changing platforms. And so each functions differently. And you have to consider, again, like we were talking about, the broader context and what exactly the post. And some of these are very going to be hard to decide cases, but you need to consider that an official does not necessarily purport to exercise his authority simply by posting on a matter within it. So just because he expresses an opinion about the city council vote doesn't mean he's actually exercising his authority.
Boy, it sounds to me like this is a pretty squishy line that courts are going to have a hard time figuring out when public officials cross that line. Is this really a victory for the First Amendment, or is this a victory for public officials being able to slap down critics?
Well, I think it's a lot clearer than the previous standard that the Ninth Circuit had set. That was an appearance and content standard, which would have turned basically most private accounts into de facto public forums and expanded what is considered state action very broadly. But for people who actually care about the First Amendment, I don't think we really want to be turning all kinds of private accounts into public forums and deeming them government forums.
Mm-hmm. Kyle, you have a view on this?
Yeah, I mean, one salutary effect of this may be to help clarify for those public officials. So the city manager in this case did not have his account designated either personal or official. And so now there is a clear test from the Supreme Court. And if you're a local official and you don't want to be taken into court and sued over your use of Facebook, you can have a personal account and you can have an official account, and you got to keep that stuff separate. Again, here is from the syllabus of the court ruling. It says, a post that expressly invokes state authority to make an announcement not available elsewhere is official, while a post that merely repeats or shares otherwise available information is more likely personal. So the way I read that is, even if it's your personal account, or if it's not designated either personal or official, if you start doing city business on that account, that post then is liable if you start blocking people on it, because you can't block people from government business. And so one result of this might actually be fewer cases along these lines if it encourages these local, state, federal officials to keep their business in one place and their personal lives in another place.
All right. So it's going to be interesting to see how this is interpreted. I don't know how well this test will hold up, but I take Alicia's point that it's at least clearer than what we had before. All right. Thank you, Alicia. Thank you, Kyle. We'll see what the Supreme Court does this term on these First Amendment cases. This could be a blockbuster term for First Amendment. We appreciate our audience listening. We're here every day on Potomac Watch. Hope you're here tomorrow as well. Thanks for listening.